Welcome, Mr. Craddock.
Thank you very much for inviting me here today. Can you hear me now? Thank you so much for inviting me here today. My name is Josh Craddock. I'm a Colorado attorney and a constitutional legal scholar affiliated with the James Wilson Institute, a legal think tank. I'm a graduate of the Harvard Law School and a former clerk on the United States Court of Appeals for the 10th Circuit. I'm also a fifth-generation Coloradan with strong ties to Pueblo. When my ancestors moved to Colorado in the 1880s, they actually settled here in Pueblo, and they're buried in the cemetery just down the road. I'm pleased to offer my testimony today on my own behalf, and not on behalf of any employer or client, about the status of Colorado abortion law and their effect on this community. Many are surprised to learn that Colorado has among the most radical abortion laws in the nation, and indeed in the world. In Colorado, abortion is legal through all 9 months of pregnancy up until the day of birth. Colorado is one of only 7 states without any limits on when an abortion can occur during pregnancy. In fact, Colorado is less protective of unborn life than nearly every other country in the world. Only a handful of countries, including China, North Korea, and Vietnam, allow abortion as late as Colorado. Yet under the 2022 Reproductive Health Equity Act, RHEA, abortion was declared a fundamental right throughout pregnancy, and all legal rights were stripped from unborn children. RHEA effectively made abortion an unregulated industry in Colorado. The so-called Care Clinic here in Pueblo advertises surgical abortions up to 24 weeks of pregnancy. According to the Mayo Clinic, at 24 weeks of pregnancy, when the baby is about 22 weeks old developmentally, the baby's fingerprints have begun to develop, and the mother might feel her hiccup in her womb. Babies born prematurely at this age have actually survived outside the womb. Here's a picture of the baby's face at 6 months, right? 22 weeks old, 24 weeks gestation. You can skip to the next slide. Yet Colorado has no law protecting born alive infants like those who would survive abortions at this stage. No Colorado law clarifies that infants who survive failed abortions are entitled to reasonable measures to save their lives. The Colorado Department of Health is not required to keep records of how many children are born alive after abortions. But in Minnesota, where such record keeping is required, 24 babies were born alive after attempted abortions between 2015 and 2022, according to Minnesota state health records. That means that in Colorado, a 22-week-old baby born prematurely in the labor and delivery ward that is regulated enjoys all the rights of any other Colorado citizen and will be given the highest standard of care in the NICU. But a 34-week-old child in utero enjoys no such rights at the abortion clinic. And in fact, if she survives a failed abortion, the doctor is under no obligation to provide life-sustaining care. Up in Boulder, abortionist Warren Hearn has offered abortions for the last 50 years, even after 34 weeks of pregnancy. That's 32 weeks of developmental age. At that age, at 32 weeks gestational age, right, from last menstrual period, at 32 weeks, the unborn baby practices breathing and her fingernails are visible. All of her internal organs are developed, her fingers and toes clearly visible. In an article for Slate magazine authored by Dr. Warren Hearn in 2003, Hearn asked in the title of the article, "Did I violate the partial birth abortion ban?" And he described how he performed an abortion on a baby that was 17 weeks gestation. Quote, you can skip to the next slide. "I inserted my forceps into the uterus and applied them to the head of the fetus, which was still alive, since fetal injection is not done at that stage of pregnancy. I closed the forceps, crushing the skull of the fetus, and withdrew the forceps. The fetus, now dead, slid out more or less intact." You can take that down. In 2022, there were 487 abortions at 21 weeks gestation or later in Colorado, well past the time when babies can feel pain, which is a disturbing increase of 186% from 2021. That's according to self-reported data from clinics, which they're not required to provide, but they voluntarily provide. There's no oversight or audit of those numbers, but those are the numbers given by the clinics themselves. Abortions in Colorado may also be performed by non-physicians. Under Colorado law, non-physician healthcare providers may perform abortions if they're acting within their professional scope of practice. In fact, according to RIA, there can be no prosecution, punishment, or any other restriction on the individual's absolute right to access abortion. So in theory, anyone could perform an abortion and there would be no prosecution, punishment, or any restriction. Non-physicians, such as nurse practitioners, nurse midwives, and physician's assistants, are also permitted to prescribe abortion pills in the first 10 weeks of pregnancy through telehealth, without even having an in-person consultation. Many abortion businesses, including Planned Parenthood, which Jack Teeter represented, prescribe the abortion pill beyond the 10-week limit as a matter of official policy. And telehealth providers do not always require that the patients be physically located in Colorado during the consultation, allowing for abortion tourism. An in-person consultation would normally involve counseling about alternatives and a discussion of the risks, including the importance of accurate gestational dating, Rh-negative identification and response, and confirmation of a non-ectopic pregnancy. Dispensing abortion pills without an in-person doctor visit also heightens the risk of abortion coercion. It enables abusers and predators to more easily acquire abortion pills, which they can use to pressure mothers to consume or even surreptitiously administer to unsuspecting women. The American College of Obstetricians and Gynecologists reported that in 2007, the prevalence of intimate partner violence was nearly 3 times greater for women seeking an abortion compared with women who are continuing their pregnancies. So these are women who are especially vulnerable. But neither the CDC, nor the Colorado Department of Health, nor the Guttmacher Institute, which is the research wing of Planned Parenthood, record or even report coerced abortions or coerced chemical abortions. Those are not reported or recorded in the FDA's publication of adverse event reports. Women who obtain abortion pills are also denied information in Colorado about abortion pill reversal. Abortion pill reversal is a safe process that allows a woman a chance to continue her pregnancy if she should change her mind after taking the first mifepristone pill. But in 2023, Colorado passed a law prohibiting medical professionals from providing information and access to abortion pill reversal. So much for choice. The law also bans medical professionals from even advertising abortion pill reversal. Now, because unborn children have no legal rights in Colorado, our law doesn't recognize any injury to an unborn child when he or she is killed by violent criminals. 38 states have fetal homicide laws, but Colorado isn't one of them. In 2018, when Christopher Watts murdered his pregnant wife and 2 toddlers in Frederick, Colorado, he wasn't charged with the death of his unborn child. When lawmakers tried to ensure that prosecutors could charge people like Christopher Watts for killing his own unborn child, Planned Parenthood's Kathy Alderman opposed the bill and called it dangerous. Now, with Amendment 79 on the ballot, late-term abortion would be an unregulated abortion would be enshrined in the Colorado Constitution if it passes. The amendment is so broad that it could actually prohibit Colorado legislature from passing laws in the future to regulate safety or protect unborn children from abortion in any way. And it attempts to restrict local communities from deciding what their policies should be with respect to abortion. It would also have the effect of repealing the existing constitutional ban on state and local funding for abortion. So this would require Colorado taxpayers to fund abortion through Medicaid or state or local government employee health insurance plans. Now this goes to the last point on, I believe it was Mr. Romero's presentation, where he pointed out that private health insurance wouldn't be covered by Amendment 79, and that's true, but it fails to take into account how Amendment 79 would interact with existing Colorado law. That's because a 2023 law enacted by the legislature, SB 23189, requires large employer health benefit plans issued or renewed on or after January 1st, 2025 to provide coverage for the total cost of abortion without policy deductibles, co-payments, or co-insurance. Individual and small group health benefit plans must also provide this coverage if the HHS confirms that the state's determination that the coverage is not subject to state defrayal pursuant to federal law. So the combination of that 2023 law and the Amendment 79 would effectively require, right? It's still going to require private health insurance plans to cover abortion without any deductible or co-insurance or anything like that. So if Amendment 79 passes, that means that public entities and private entities are going to be paying for abortions at taxpayer expense and without deductibles. Now, in 2022, because of Colorado's radical abortion laws, nearly 30% of abortions in Colorado were performed on non-residents who traveled here from out of state. NPR Colorado actually described it in an article as a surge of travelers seeking abortions here. According to Provisional Colorado Health Department data, again self-reported, about 4,200 patients came to Colorado out of about 14,400 abortions performed. Now, to put that number in perspective, the leading cause of death in Colorado in 2023 was cancer, which killed 8,400 people. If the deaths of unborn children from abortion were counted, surgical abortions would account for nearly the top 2 causes of death, cancer and heart disease combined. The barbaric abortion policy of communist countries like China, North Korea, and Vietnam shouldn't be a model for Pueblo. Under Article 20, Section 6 of the Colorado Constitution, home rule cities like Pueblo are vested with and shall always have all other powers necessary, requisite, or proper for the government and administration of its local and municipal matters. That section grants and confirms the full right to self-government in both local and municipal matters. Now, you heard Jack Teeter say that, well, RIA tries to take some of those rights from Puebloans and to decide what's right for their community. But he was specifically talking about zoning, which is traditionally a local area of concern. But nothing in RIA says that a state or a local ordinance like here in Pueblo could do anything broader than what is permissible under federal law. Right? So that's something that's been ignored in this conversation. The people of Pueblo should have a say in what's right for their community, and not just the legislators up in Denver or the abortion industry activists that profit from their abortion and apparently are involved in writing their own regulations. That's unusual for a regulated party. Thank you.
Well, thank you, Mr. Craddock. Thank you, Mr. Craddock. I'm glad that we have connected and that you could bring a professional legal opinion to the table. Any questions from council?
I got one.
Okay. Councilor Gomez.
I'm trying to figure out where we're going from here. We hear both sides openly, and I just wish we would be a little bit more behaved, but that's just me. I know this is an emotional issue for a lot of folks, but I know this is an emotional issue for a lot of folks, but we got to respect each other for what it's worth. But I appreciate everybody coming tonight, and I'm just kind of figuring out where we're headed.
Go ahead, Councilor Martinez.
Yeah, thanks for coming to speak and giving your perspective tonight. This is a yes or no question. Is abortion currently regulated in the state of Colorado?
It is subject to the same regulations, like they're required to have insurance, for example. Doctors who perform abortions are required to be, subject to the medical board. But as I pointed out, doctors aren't even required to. Right? You could have non-doctors performing abortions in the state of Colorado. So sure, there are some regulations, but nothing that would ensure health or safety or protect the lives of late-term babies subjected to abortion.
So yes, abortion providers are regulated in the state of Colorado.
The abortion industry is subject to some regulations that are tangential, but there is no one going to inspect safety, for example. There's no one going to inspect clinic health and safety. Those types of typical regulations are not seen here in Colorado.
Do other physician offices also get inspected, like you were just suggesting?
In many states, such inspections are required in abortion facilities, and in Colorado, hospitals, for example, are subjected to those sorts of inspections.
I asked about physician offices.
Not typically outpatient physician offices, but here we're talking about an invasive surgical procedure where it would make sense.
This is another yes or no question. Can Pueblo consider regulating any type of abortion care or abortion service under RIA?
Yes.
That's all.
Well, why don't you explain that further, Mr. Craddock?
So the answer is yes. RIA, as a state law, preempts local ordinances, right, as a general rule. But that same is true of federal law as to state law, right? Article 6 of our U.S. Constitution says that the federal Constitution and the laws of the United States are supreme over state law. So if our state law is broader than what is permissible under federal law, then the state law is preempted to that extent. So for example, federal law prohibits partial birth abortions. If RIA were read to be so broad, protect a right to abortion so broad as to allow partial birth abortions, that would be nullified, and this council would be perfectly justified in passing an ordinance ensuring that partial birth abortions are not permitted, consistent with federal law.
You know, the Attorney General, Phil Weiser, who is the highest legal authority in the state of Colorado, why do you think he would disagree with you?
Oh, that's a great question, and I'm glad you asked. I reviewed Phil Weiser's letter, and it's incomplete because he fails to consider how federal law is supreme over RIA to the extent they are inconsistent. So he gets an incomplete grade on that letter, and he's doing it for political purposes.
I could say the same thing about your testimony.
I'm not an elected official. I'm not an elected official who gets donations from Planned Parenthood. I'm not an elected official who gets donations from Planned Parenthood.
So we attempted this before, Mr. Craddock, when the late-term abortionist who is now deceased. It's my understanding there are only 4 in the country, correct? Now 3, with him being deceased. Is that correct?
And Warren Hearn up in Boulder is one of them, yes.
Yes, and the doctor in Boulder is one of them.
Yep.
And I noticed that that when I was watching the licensing for our current clinic, which that is one of the things of the regulations, that we have to have a licensed physician basically hang their shingle there, correct? Do they have to be there?
So under Colorado law, even non-physicians can perform abortions. So that's goes to the part about how unregulated the abortion industry is, and how we have regulated parties writing the laws that are supposed to regulate them.
Okay, and so it looks like their newest doctor, or their newest abortionist on call, is based out of San Antonio, Texas. And there was a lapse that I found in, all I need to do is just follow the licensing on Dora, and I see that Dr. Carhart died in April of 2022, and the current doctor there was practicing. They were performing abortions, but his licensing wasn't valid until December of 2022. So that was kind of prohibited. They were breaking the law there, I would think, or maybe there wasn't. I'm asking a lawyer.
Yeah, I don't know the specific facts of this case. So I know that Carhart died in 2023, and I don't know the specific facts of how they're, what the local licensure requirement was there.
Okay. So, all right. Any questions? Any further questions from council? Go ahead, Councilor Gomez.
Yeah, for what it's worth, I just think it's been okay to hear both sides tonight, and this is the way we should be handling a lot of these issues. So it's not a waste of my time. I hope it's not a waste of this council's time to hear both sides.
Councilor Latino.
I'd just like to say that basically federal law supersedes anything the state brings up. So I think that's something that we have to understand, okay?
That's right. And so there's several federal laws that would be applicable here. Of course, there's the partial birth abortion ban, which was the one that, Warren Hearn was saying am I violating it by doing these late-term abortions? He was asking that in a published article in Salon, was it Slate or Salon magazine, right? And so that's one federal law that could be at issue. And state law can't create a right to abortion that's broader than what federal law allows. The second aspect of this is actually federal law that prohibits the interstate shipment and carriage of abortion pills and devices across state lines through the Postal Service, across state lines through common carriers like DHL or FedEx, or through the U.S. Postal Service, anywhere. And so that's a federal law that, an ordinance here in Pueblo could address and say, hey, look, in Pueblo, we're just establishing that in Pueblo we're going to follow federal law. There's no inconsistency there between state law and the local ordinance. And if there were, the state law would have to bend in favor of the federal law.
Okay.
Thank you.
Thank you, Mr. Luciano. How many communities has this particular ordinance been in, and across how many states?
Yeah, I know that there's been a number of different communities that have enacted ordinances like this through a number of different states. Hobbs, New Mexico is one of them nearby. There's many cities and localities in Texas. I'm aware of some in Illinois and Indiana. So across the country, there are dozens of ordinances. In Colorado, Pueblo would be the first, and I encourage you to do so.
Okay. And so, Sarah's got another question? Okay.
Mr. Gifford, our own city attorney that represents the city and this council, what's your legal opinion? Do you think that would federal law trump state law?
What we're referring to is the Comstock Act, I believe, of 1873, which was amended in 1972 or 73 to prohibit the mailing of abortion services. Now, much in the same way that Attorney General Phil Weiser issued a letter, the U.S. Attorney General has also issued the same letter, which I don't think necessarily agrees with what's being presented here tonight. Currently, the ordinances that have been passed in New Mexico are at the New Mexico Supreme Court awaiting decision. They were challenged immediately and stayed. And if you were to look at where these ordinances have been passed, the majority of them have been passed in Texas, and the majority of those have been passed in communities of 300 to 400 people. Tiny towns, which I don't even know if they would have an abortion clinic there. Furthermore, I believe abortion is banned in Texas at 6 weeks. So it's a totally different situation in New Mexico, in Texas, and in Colorado. I don't see anything that's been presented this evening that would make me think that we could pass an ordinance saying that we were going to enforce the Comstock Act and somehow prohibit abortion based on RIA, which is very clear. It uses just about every synonym you can have for the word don't when it comes to restricting abortion. And I'm not meaning to be glib. I'm not meaning to be glib. This is something that's very serious, and I think everyone has a serious opinion on this. So until I'm presented with something that states otherwise, I don't think that we would be wise to pass this ordinance.
Thank you.
Mr. Craddock.
Yeah, thank you, Mr. Gifford, for that intervention. I want to add that on the Comstock Act, which is 18 U.S.C. 1461, 1462, it's been around for about 150 years, but it was most recently amended and revised by Congress and President Clinton in 1996 to actually expand 1462's application to interactive computer services, making it illegal to use the internet to ship or receive abortifacients. And actually, Section 1461 continues to be included in the most recent edition of the U.S. Post Office's Publication 52, which states that any article or instrument designed, adapted, or intended for producing abortion is non-mailable. So I understand that the Attorney General, Merrick Garland, has issued, the Office of Legal Counsel has issued an interpretation of what this Comstock Act means. But courts have yet to weigh in on this in full. One judge of the Fifth Circuit, U.S. Court of Appeals for the Fifth Circuit, has opined that this law is still fully enacted. And in fact, there were questions about this before the Supreme Court, where at least 2 Supreme Court justices have indicated their position, suggesting that the Attorney General's interpretation of this law might be misguided. So I think it's hardly a settled case that just because the OLC issued an opinion giving this an extraordinarily narrow interpretation, that is the last word. My final comment is that to the extent 1461 and 1462 mean what Attorney General Garland said in the OLC opinion, then there would be no conflict between federal law and state law, and thus no conflict between state law and the ordinance. So either way, this council has authority to pass such an ordinance, because either there is a conflict with state law and federal law trumps, right? Or there is no conflict with state law whatsoever, because there's no conflict with between state and federal law.
Thank you. Mr. Boston.
I just want to appreciate everybody for coming tonight, and more so a point of order. I understand everybody's very passionate about different issues that get brought to us, whether it be the bathhouse, the needle exchange, or this issue at hand. I think it's very important, as the elected officials that are voted in these positions making these decisions, we do get to hear both sides and all pieces of an argument. I know everybody is passionate, but when somebody is giving information that may help us in a situation make a more informed decision, I do please ask that you respect everybody in the room. It is okay to disagree on things, but just please be respectful so we can get the facts on both sides so we can make a more informed decision. It's really hard for me to hear. I may be young, but my ears aren't as good as they used to be. So just like, future tense, anytime anybody is up here giving their time, whether it's through public comment or giving their opinion on any matter, just please be respectful so that we can hear and make a more informed decision that is in the best interest of this public. So thank you for that.
Thank you, Mr. Boston. Councillor Martinez.
I guess this is just more me being curious. If what you're saying is true and federal law trumps state law, why haven't you sued the state over RIA?
Well, so to be clear, there's right now you have to have a cause of action to sue, and so what the ordinance would be providing a private cause of action, for example, to private citizens to bring a civil suit for enforcement to ensure that federal law is followed in the within Pueblo. Right? So because to sue, you have to have what's called a cause of action, like some legal right granting you authority to sue. And so that's actually what the ordinance would allow, to ensure that federal law is being followed.
Perhaps no other Colorado community, though, has implemented this because they know that RIA protects any sort of municipality from regulating any type of abortion service.
Well, I don't think that's the case, because the ordinance itself is, again, as I explained, the RIA cannot preempt the ordinance if the ordinance is consistent with federal law, right? Because federal law trumps state law. And so to the extent that there is any inconsistency between federal law and state law, they can't preempt the ordinance.
So, Mr. Craddock, RIA was brought forth by state legislation. It was not brought forth by a vote of the people. And so when RIA was put in place, it was put in place up at the Capitol. The people didn't vote on it. We get a lot of laws that are not voted on that try to take away our home rule authority to decide what we feel is best for our community. We're suffering from, the needle exchanges and the open drug use and the crime because of the decriminalization. And it just goes on and on and on. And I'm not for, I know that a good large part of my community is screaming for crime and safety, health and safety. And so I am going to bring issues forward so that people have a better understanding, even when they're voting here on Amendment 79. Are we going to continue to feed the beast, or are we going to try to, if abortion's going to be legal, we're going to try to, as communities across this state, try to make legislators accountable and the abortion clinics accountable accountable when they're treating women for these procedures. It's unfortunate that this state doesn't, we have such a radical abortion law that goes through the 9th month. That's just a shame in itself. I mean, there's no restrictions. I don't know that pro-choice has benefited women's choice if they're not protected, health and safety wise. And so I feel like the opposition to putting regulations on it is more pro-abortion than they are pro-choice. But that's just my personal opinion. And so I thank you for your time this evening. Anyone else? All right. Thank you.
Thank you very much.
We will adjourn. The time is 6:36, and we will adjourn.